Kia ora. I'm Rayner Thwaites, a senior lecturer at the University of Sydney Law School, formerly a lecturer at Vic. I'm very glad to be part of the Government Law Conference, and my thanks to Dean and Claudia for asking me to talk to some aspects of developments in the Australian courts in relation to Nauru and offshore processing more generally. Now, the Australian cases on offshore processing are forcing the Australian Government and the Australian courts to tease out the legal accountabilities involved, or potentially involved, in Australia's arrangements with its neighbours, and are of interest to New Zealand, I think, for that reason. To look first at Australian courts applying Nauruan law. So on 13th of March 2018, the treaty-based appellate jurisdiction whereby the Australian High Court can hear appeals as of right from the Supreme Court of Nauru was unilaterally terminated by Nauru. This treaty right had provided for over 40 years for an appeal from the Supreme Court of Nauru to the Australian High Court. Now, Nauru's notice of intention to terminate was issued following 3 cases in late 2017 in which appeals from the Nauruan Supreme Court to the High Court of Australia were successful. One of those cases related to sentencing of those who protested outside the Nauruan Parliament in opposition protests in June 2015. Now, the High Court's Nauruan jurisdiction was odd and not without problems, but unfortunately it hasn't been replaced by anything better. The termination of the High Court's jurisdiction forms part of the deterioration of democracy and the rule of law with which in Nauru, with which the New Zealand public is familiar. Now, in a final twist on the High Court of Australia's Nauruan jurisdiction, I note that 2018 has been a bumper year for Nauruan law in the highest appellate court, in the High Court of Australia. The court delivered a record 13 judgments on Nauruan law, all involving refugee processing. This is partly a function of the fact that the imminent termination of the jurisdiction sparked a flurry of applications. All of those cases were instituted to use the language of the treaty before the termination date of 13 March 2018, and so will now or shortly begin to dry up. Secondly, sort of taking foreign law, another avenue of accountability is foreign law as a constitutional limit on Australian powers. To begin, in 2016, in the decision of Namar and Pato, the Supreme Court of Papua New Guinea held detention on Manus to be unconstitutional and illegal. Then in 2017, the High Court of Australia delivered judgment in Plaintiff S195 of 2016 on the effects of that ruling of the Papua New Guinea Supreme Court on the Australian branches of government. And the take-home point from the Australian High Court's ruling, and I quote, was that there should be no doubt that neither the legislative nor the executive power of the Commonwealth is constitutionally limited by any need to conform to the domestic law of another country. The High Court immediately went on to situate that statement, clarifying that Australian officials could still be accountable, of course, under Papua New Guinea law and any Australian laws with extraterritorial effect. I note that the decision in Namar and Pato has surfaced in Australian law in other ways, notably in a claim for compensation lodged on behalf of Manus Island detainees in the Supreme Court of Victoria, which the Australian government settled for $70 million. Just turning to a last avenue of accountability, the extraterritorial application of Australian law. As noted, the central ruling in Plaintiff S195 left open extraterritorial application of Australian municipal law to Australia's arrangements with other countries. And for those interested in foreign relations law, the application of domestic law to the external exercise of executive and legislative power. In the case of Plaintiff M68 of 2015, another case of Nauru and refugee processing, the High Court has provided material of interest. So in conclusion, it's usually cold comfort to those who are the subject of the offshore processing regime. But the regime and the cases on it have developed Australian legal thinking. It's seen the Australian courts make determinations under foreign law, address the ability of foreign law to serve as a constitutional limit, and considered the application of Australian constitutional and legal constraints to its government's activities overseas. Now, securing legal accountability under these offshore processing arrangements is difficult. Those arrangements have been entered into, at least in part, in an attempt to draw on a foreign country's legal sovereignty as a shield against legal or at least judicial accountability under Australian law. My hope is that lawyers trying to ensure legal accountability for and under Australia's processing regime, and beyond that, in trying to ensure accountability under intergovernmental arrangements between countries more generally, can draw on a trans-Tasman dialogue on these issues. Thank you.